What is tax court? Tax court is an opportunity to have your tax dispute reviewed by an independent federal judge before you ever pay the IRS. That single feature changes the whole game. I am attorney Jim Daloisio, Director of Legal Services for Torchlight Tax. If the IRS has arbitrarily denied a credit or deduction, they are forced to defend that decision before an impartial judge. Yet many Americans who would benefit from tax court never use it. Why? The reason is simple. Very few tax firms deliver the service and thus do not recommend it. Only about 0.06% of CPAs and EAs are qualified to represent you in U.S. tax court. Among general tax preparers, about 0.02% qualify, about 1 in 5,000 tax preparers. That's why most firms never mention tax court, because they can't provide the service. At Torchlight Tax, we can and do. And that changes everything about your leverage with the IRS. When you file a timely petition to tax court, the law pauses the IRS from assessing and collecting the disputed deficiency while the case is pending. Interest still accrues, and other years not in the petition aren't protected, but on the year you're fighting, forced collection stops. That pause levels the playing field, so your evidence and the law, not IRS momentum, decide the result. Here is how it works in the real world. Your doorway into tax court is the IRS Notice of Deficiency, the 90-day letter. From the date the IRS mails that notice, you have 90 days to file a petition to tax court. If the notice is addressed to you outside the United States, you have 150 days. File on time and two things happen immediately. The court gets jurisdiction to redetermine your tax, and the IRS is legally restricted from assessing and collecting the deficiency at issue while the case is pending. Miss the deadline, and you're usually forced into pay first, sue later in another court. Timing is everything. We file early and keep rock-solid proof of filing. Once the petition is filed, your case is docketed and assigned to IRS Chief Counsel. The culture of the court is informal exchange first, trial second. We trade documents, stipulate facts, and narrow what is actually in dispute, sometimes called Brannerton practice. If numbers can be reconciled or the law clarified, we craft what is called a principled settlement, which is not horse trading or meet-in-the-middle guesswork, but a resolution grounded in what the record proves and what the law actually supports. It's common for docketed cases to be referred to the Independent Office of Appeals even after filing, giving you a fresh settlement look while a real trial date looms. That looming date, standing in front of a judge who does nothing but tax, often makes the IRS far more realistic. We had one client at Torchlight Tax from whom the IRS was demanding $150,000. We sent the data to the IRS showing that he did not owe the money. They did not change their determination. We exercised the client's right to go to tax court and filed the petition. The tax court sent it back to the IRS for review, and the IRS canceled the debt. If settlement isn't there, we try the case. There's no jury. A specialized federal judge hears tax all day, every day. We present records, witnesses, and law. In the right circumstances, if you present credible evidence and meet your substantiation and cooperation duties, the burden on some factual issues can shift to the IRS. And for penalties, the government must make the first showing before penalties can stick. The court can also determine your due and overpayment and order a refund with interest. In certain cases, if you substantially prevail and meet the criteria, you can even recover administrative and litigation costs. Add to that real discovery, subpoenas, depositions when appropriate, and a judge to referee disputes. And you see why a docketed case has power that ordinary back and forth with the IRS does not. Clients often ask if they must go to court. Usually, no. Most cases resolve through documents, stipulations, and negotiations, without testimony, especially when we have a strong paper trail. If we do need a hearing, the court holds calendars around the country and frequently proceeds by Zoom.gov. Your notice-setting case for trial will say whether it's in person or remote. When appropriate, we can ask the judge to proceed by Zoom. Remote sessions follow the same deadlines and exhibit rules as in-person court, which makes tax court more accessible than ever. Another common question is where appeals and offers in compromise fit. Many audits go to appeals before a statutory notice. If you don't resolve it and a notice of deficiency issues, tax court is next, if you file on time. For collection matters, liens and levies, you typically get a collection due process hearing with appeals first. If you disagree with appeals notice of determination, you can petition the tax court, generally within 30 days, and a judge reviews whether appeals acted reasonably. That review can include whether an offer in compromise OIC was fairly considered. Outside the CDP context, a bare OIC rejection by itself doesn't create tax court jurisdiction, but here's the key practice point. You do not need to dismiss your tax court case to pursue an OIC. The IRS can consider an offer while the case is docketed, coordinating with Chief Counsel. In fact, dismissing a deficiency case to go do an OIC can backfire. By statute, a dismissal other than for lack of jurisdiction is generally treated as a decision sustaining the IRS's deficiency. Keep the petition alive, pursue settlement, and offers in parallel with counsel's involvement. You can also choose the small tax case track when the amount in dispute is modest, generally $50,000 or less per year. It's faster and less formal, but decisions can't be appealed. Regular cases preserve appeal rights, but take longer. We help you choose the lane that fits the dollars, the documentation, and whether a legal issue might benefit from appellate review. Let's talk rhythm and expectations. You receive the 90-day letter. You don't wait until day 89. You file early, clean, and complete. The court sets your case on a session calendar months out. In that window, we organize your books and records, stipulate what isn't really in dispute, and press for a principled settlement. If settlement is there, we take it. If not, we present your case to a judge who has no stake in the IRS's numbers. Throughout that timeline, the statutory pause protects you from forced collection on the deficiency you're fighting, keeping the field level while the law does its work. There are boundaries. The petition protects only the years and issues actually in the case. Other unpaid balances are still collectible. Interest doesn't stop. Existing liens don't evaporate. And nothing works if you miss the filing window. Day 91 is day 91. Precision and timing are not optional. Now step back and see the strategy. Tax court turns a one-sided IRS determination into a two-sided, law-driven process supervised by a neutral judge. It brings real discovery, real standards of proof, and the possibility of a trial. It also creates the leverage that solves most cases before trial, because counsel knows that sooner or later, their position must stand up in front of a federal judge. Practical considerations. We exist in the real world. You can represent yourself in tax court. Your routine tax professional cannot. A tax attorney or specially trained CPA or EA can. If the case is small, representing yourself is probably a good idea. Now let's look at this from the IRS perspective. The IRS is overloaded, and not all of its staff are well-trained and experienced. Do not get me wrong. There are many good, competent people there. But suppose you feel the IRS is wrong, and their determination is wrong. When you apply to tax court with an attorney representing you, the IRS knows you are serious, and your case is assigned to an IRS attorney. He reviews the case. He is probably overloaded. Does he really want to take this case to court? Or would he rather it be settled in the Independent Office of Appeals? He can see the whole record of your case, and the earlier IRS staff working with you are not tax attorneys. Did they make a mistake? Did they refuse to accept data from you because it was past a deadline? Was your supporting bookkeeping incomplete, and is it now completed? Let's be real. Between government shutdowns and DOGE, Department of Government Efficiency, cuts, the attorney would probably happily have it settled elsewhere. So would the judge. And this is where Torchlight Tax comes in. While 99.98% of tax preparers can't petition tax court, we can. Our first step will be to determine if tax court is the right solution. If so, we filed your petition on time to lock in protections. We force discipline into the case. Facts stipulated, records organized, law applied. We work every settlement angle available, including appeals on docketed cases and OICs where appropriate. And we try the case when that is the principled path to the right result. Now, whoever reviews your file in appeals knows it is heading into tax court if settlement is not reached. You get a fresh look at your case. You also have had the chance to clean up your accounting and documents to support your case. If you've received a 90-day letter or have some other tax situation, contact Torchlight Tax at 877-758-7797 or info@torchlighttax.com for a free consultation. Give us a call and we will review your data and help you sort out what your next step is. For other tax savings and asset protection strategies, view our blog articles and videos on the Torchlight Tax website and YouTube channel. We have 400 articles and videos and a lot of excellent tax and asset protection strategies you can learn. If you found this video helpful, please like it, share it, and subscribe to our YouTube channel. Thanks for watching.